Today, we're diving into a powerful critique of South Korea's constitutional court. The central argument is pretty explosive, that the very institution designed to be the ultimate guardian of the law has actually started to undermine it. So, let's break down the evidence behind that claim piece by piece.
It all really boils down to this one question. Is a court's job to protect the law from the people, acting as a brake when passions run high, or is its job to ratify the will of the people as law, essentially giving a constitutional seal of approval to popular opinion? This is the core tension we're going to explore.
All right, part one, a shield against mob rule. Let's first establish what the court, according to this view, was supposed to be.
This whole idea of judicial review goes way back to the early days of the United States, with a famous case called Marbury v. Madison. See, the people who designed these systems weren't just afraid of a king, they were also afraid of what they called the tyranny of the majority, the very real danger that a fired-up crowd could simply vote to trample on fundamental rights and laws.
The logic behind it, laid out by Chief Justice John Marshall, was actually pretty straightforward. It rested on three basic ideas. 1. The Constitution is the absolute supreme law of the land. 2. The court gets the final say on what that law actually means. And 3. If any regular law conflicts with the Constitution, well, the Constitution wins, and that law is toast. This setup creates a really powerful check on raw political power.
So, here's the bottom line. The judiciary was meant to be a kind of cooling mechanism, a check and balance. Its purpose wasn't to ride the wave of public anger, but to make sure that anger didn't smash through the fundamental rules of the system. It was designed to be a leash, not a rubber stamp.
Okay, on to part two, the court on trial. Now we get to the heart of the accusation, that the Korean Constitutional Court has flipped this original purpose completely on its head.
And here's where the critique really takes shape. The court's job is supposed to be what's called constitutional norm control, basically asking, does this law follow the rules of the Constitution? But, the source argues, it is shifted to something totally different, preemptive fact-finding. It started deciding what happened in a case before a criminal trial can even begin to investigate, which effectively gives a green light to whatever the political momentum is at the time. And you can imagine, this creates some huge problems. The source argues that the court ends up relying on incomplete records, on statements that haven't been properly challenged. It confirms facts without the tough, rigorous cross-examination you'd get in a real criminal trial. And the result? You get these massive political judgments that are irreversible, even if the facts they were built on later fall apart in a different court. So, part three controversial rulings. The source builds its entire case around three specific, high-profile decisions.
First up, the impeachment of President Park Geun-hye. The argument here is that this is a prime example of the court overstepping its bounds, of establishing facts that were still being hotly debated in criminal courts.
The critique zeroes in on the court's reasoning. It points out there was no direct proof that the president personally received any money. So to connect the dots, the court introduced two pretty creative ideas, the concept of an economic community, which isn't really a standard legal term, and the idea of an implied request for a bribe, which is, highly subjective. The source claims the court essentially made up these ideas to create a factual basis for removing a president from office.
The second case involves the impeachment of Minister Lee Sang-min, and the source claims we see a very similar pattern here, a pattern of what it calls flawed and premature fact-finding.
In this instance, crucial parts of the ruling were built almost entirely on the testimony of just one person. But later on, contradictory evidence, things like CCTV footage and other witnesses started to surface. According to the source, the court didn't wait. It preemptively chose the most politically damaging interpretation of events and cemented it as fact before a full investigation could even run its course.
Now, this third case is different. It's not about a single person. It's about the machinery of the democratic process itself, an election. And in the source's view, that makes it the most dangerous ruling of them all.
Okay, this might seem really technical, but the distinction is critical. The election law is very specific. It requires an official to physically stamp early voting ballots. This is an intentional, physical act of verification by a specific person. What the National Election Commission did instead was use a pre-printed image of a stamp. The source argues this completely guts the idea of individual accountability and, worse, opens the door to the mass, untraceable reproduction of ballots.
And what was the court's decision? By a vote of 7-2, it ruled that the printed image was perfectly fine. They argued it fulfilled the purpose of the law, and that the physical act of stamping itself wasn't essential.
Okay, part 4, how other courts differ. So you might be wondering, is this kind of approach normal? Well, the source puts it in context by comparing it to the systems in the US and Germany. The difference with the U.S. is just night and day. In America, impeachment is considered a political question. What that means is the Supreme Court wants nothing to do with it. The fact-finding, the trial, the judgment, it's all left entirely to Congress. The idea of a court preemptively ruling on facts for an impeachment just couldn't happen there.
And Germany's court, which was actually the original model for Korea's, is also completely different. It has a strict rule to avoid rejudging facts that have already been established in lower courts. Plus, its standard for impeachment is incredibly high, making it almost impossible to actually remove an official.
This table really lays out the contrast. For who judges an impeachment? In the U.S., it's Congress. In Germany, it's Congress with a very strict court check. But according to the source's view of South Korea, the court is the final judge. On fact-finding, the U.S. court is out, the German court is limited, but the Korean court takes an extensive, preemptive role. It's a unique and, the author argues, uniquely powerful position.
Which brings us to part 5, a system in crisis. So what's the final verdict here? The source argues this isn't about a few bad calls, it's about a fundamentally broken system.
And the proposed solution is nothing short of radical. They call it a reconstruction. We're not talking minor tweaks. We're talking about fundamentally redesigning the court's power, explicitly forbidding it from getting involved in criminal and election cases, and maybe even, if all else fails, abolishing the current model entirely.
We'll end with this powerful quote from the source material. It argues that the court was meant to be a fortress, defending the Constitution from the passions of the moment. But when it instead chooses to use its authority to ratify those passions, it stops being a fortress and becomes something else entirely, an institution that hollows out democracy from within. A pretty provocative thought to end on, for sure.